suffered the loss.
All right, so this is a two-part question. I'm sure many people are interested in knowing how fees are calculated between a lawyer and client. Are they calculated hourly like most people think they are, or is there a little bit more to it than that?
That's a very interesting question, Sumukh. Actually, what has happened is that Ontario, let's take Ontario. So we live in a very prosperous society in Canada as compared with many other countries. And the typical way a lawyer who is well educated, goes a lot of years in school, and represents the client and says, I bill $250, $300 an hour. So in many situations that may arise in a person's lifetime in a legal context can end up being solved through a very expensive legal system. But most of the time, since the solution is a custom-made arrangement and the lawyer must also pay his bills, he normally would charge by the time, especially in cases which are of litigation type, because your results are not predictable exactly. If you're dealing with something like an incorporation or something which is similar in nature to a predictable event, then the lawyer will say, okay, I'll charge you so much for the entire procedure, and that is a fixed fee arrangement. So I think that the lawyers normally charge a fixed amount because the event is predictable, or not a fixed amount, but hourly rate where the event is not fully predictable. These are two main methods of doing it.
Okay, secondly, how does the determination of fees affect the client-lawyer relationship?
Well, because you can imagine what happens is that the lawyer is a private practice, except for legal aid, where there are lawyers who help you because of legal aid paid by the government funding. Then the lawyer must make a living, just like a business person or a private practitioner, engineer or a doctor. A doctor is paid through the OHIP system. But the lawyer is making his living essentially from providing the service, and therefore, if the lawyer and the client have not talked about the fees, as many do not, then the tension will arise at some point in time. Why is this costing so much and I'm not getting my results? So that tension is not very helpful to solve the problem, legal problem, because there is a need to have a relationship of trust between the lawyer and the client, because the lawyer is making many decisions which are so fundamentally important to the client. So it is very, very important, in my view, that the relationship is defined properly in terms of what the lawyer will do and in terms of what the client will pay to do it.
And if the client disagrees with the fees, is there a course of action that can be undertaken to resolve the issue?
Yes. I think most of the time there are two main places where he can have the question of fees resolved. One is called an assessment officer, who is a person, a court official appointed, very often not a lawyer, by the court, who sits down, has a hearing between the lawyer and the client, and then if it is not resolved there, then of course, it's either or situation. Either you take it to the assessment officer, there's a procedure for that, to set it down for hearing, or take it to the small claims court, because most bills are within the $25,000 range, which is permissible to be taken to court, and the court can make a decision. But if you go to an assessment officer, he will not decide on what is called the retainer engagement of the lawyer situation, but only on the assessment of the amount that should be paid. And usually he will compromise and find a compromise solution for the two.
And how can you reduce the cost of the legal fees?
Well, I think very, very important that today with the internet and the resource material available, like Canley, CANLII.ca is a website where there's a lot of material. There are many, many websites. Ministry of Attorney General has a website from where you can find a lot of material. And I think that if you simply cannot afford, there's a legal aid. There is also University of York and Toronto in this area who can also help. There are students who can help. And it's very important to understand as much as possible of the legal system so that you can make informed decisions and then do what you can to minimize the time of the lawyer, then to try to resolve the issue in a reasonable fashion. If you take an issue and say, well, I just want to battle it out because I'm angry, then it does not resolve the question properly. So it's a question of attitude, question of knowledge, and a question of trying to understand the procedure as much as you can, so that you become like an informed consumer of legal services, and then you are in a better position to minimize the cost and find a resolution of the problem.
And is it true that the first half an hour is free?
No. What has happened is that, you see, between the lawyer and the client, a lot of distance has arisen, actually. It's a very small percentage of the population really, even in Ontario, a rich country, in a rich province, in a rich country, can afford really a lawyer. A typical problem will really cost, if you go to litigation, between $2,000 to $30,000, so I think that it is very, very expensive to go to the legal system, so distance has arisen. So what the Law Society did is to say that those who register with the system should give half an hour free. That opens the door for a person not to be too afraid to go to the lawyer's office and have a half an hour chat, feels comfortable with the lawyer, and then if he's comfortable, he says, okay, then what is your recommendation, and he continues. But those are people who want, being lawyers, who want to be providing that service and attract the client base, and opens the door for the clients. But I personally don't do that thing, and I feel that it may not provide an objective opinion, because there's incentive for the lawyer in private practice to say, well, I want to get some money from a deal that I do, like I get the client in there, and then be a special litigation type of a situation, and therefore you could end up attracting the client in a litigation or something, or advise something which is not entirely objective.
Okay, and finally, how does the conflict of interest work?
Well, our system is adversarial, which means, unlike the civil law system, the common law system is adversarial. And why is it so, actually? It is because we recognize the human frailty, that the lawyer is really making decisions as a person on behalf of one person who has a conflict of interest with another person. This conflict of interest means that each person has a different lawyer who sees the legal system and the legal opinion from his perspective, and therefore it is the reason why the lawyer is in an adversarial system, and there are two different people advising their own respective clients, and then if they cannot agree, then they go to court to have the question resolved. So that's how the system works.
Great. Those are all the questions I have for today. Thank you so much for your time.
You're welcome, Sumukh. I think it was a very useful discussion, and I hope the public benefits from this discussion. We hope to upload it in the YouTube, and it will be useful to the public. Thank you so much.